So friends, a Trump-appointed federal judge in New York just sided with Jim Jordan over New York District Attorney Alvin Bragg. The judge ruled that Mark Pomerantz, former prosecutor in the New York District Attorney's Office, Mark Pomerantz must comply with a congressional subpoena Jim Jordan issued to have Pomerantz testify about the New York State criminal investigation of Donald Trump. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, did you see the ruling by Trump-appointed Judge Mary Kay Vyskocil up in New York? I have two initial observations I want to make about her ruling before we go through it in some detail. The first observation is her ultimate conclusion, refusing to strike down the subpoena that Jim Jordan issued to have Mark Pomerantz testify before Congress. That ultimate legal conclusion is supportable, even though we all know it's obvious, it's transparent. Jim Jordan issued that subpoena in an attempt to interfere in New York District Attorney Alvin Bragg's criminal prosecution of Jim Jordan's man, Donald Trump. Even so, as a legal proposition, I believe Judge Vyskocil's ruling is legally supportable, and I have to call it the way I see it. But her ruling reads like it was drafted by a combination of Jim Jordan's PR person and Donald Trump's criminal defense attorney. Let's go through some of the highlights, some of the lowlights of Judge Vyskocil's order. And I'm going to try to go through it slowly, if only to keep my blood pressure down. Here is the opening salvo. The request by Manhattan District Attorney Alvin Bragg for a temporary restraining order enjoining, that is, stopping or invalidating, enforcement of the subpoena issued to Mark Pomerantz by the Committee on the Judiciary of the United States House of Representatives, chaired by Congressman Jim Jordan, is denied. The subpoena was issued with a valid legislative purpose in connection with the broad and indispensable congressional power to conduct investigations. It is not the role of the federal judiciary to dictate what legislation Congress may consider or how it should conduct its deliberations in that connection. Mr. Pomerantz must appear for the congressional deposition. No one is above the law. No one is above the law? Judge Vyskocil, you do recognize that Jim Jordan, the very person who issued this subpoena to Mark Pomerantz, in what we all know is a transparent attempt to help out his man, Donald Trump, to interfere in Alvin Bragg's prosecution. Jim Jordan himself criminally defied a congressional subpoena, the very kind of subpoena he just issued, and that you upheld, proclaiming no man is above the law, yet Jim Jordan is above the law. He criminally violated a congressional subpoena. He has not been held accountable. He has not been charged, not indicted, not prosecuted. So you know what? You're not starting out strong when the very person whose subpoena you are upholding, Jim Jordan, himself is above the law because he criminally defied a congressional subpoena. And friends, believe it or not, Judge Vyskocil's order gets even worse. Page 5. Judge Vyskocil says the following: the first 35 pages of Alvin Bragg's complaint have little to do with the subpoena at issue and are nothing short of a public relations tirade against former president and current presidential candidate Donald Trump. This ruling reads like it was authored by a combination of Jim Jordan's PR person and Donald Trump's criminal attorney. Judge Vyskocil continues. As I was reading this order of hers, I actually wrote down a question for myself. I asked, if Jim Jordan said, you know what, Judge, I'm issuing this subpoena to Mark Pomerantz because I want to interfere in Alvin Bragg's criminal prosecution of Donald Trump. I want to help Donald Trump stay out of hot water, and I'm willing to abuse my office and my authority as a member of Congress to do it. But I also have a little bit of a legislative purpose as well. If Jim Jordan said that about the very subpoena that he issued, would you still support that subpoena? Interestingly, after I wrote that question to myself, Judge Vyskocil answered that very question on page 13. District Attorney Bragg suggests that these are not the committee's true objectives, these meaning the stated legislative purpose, rather than the true purpose of interfering in Bragg's prosecution of Donald Trump. Bragg suggests that these are not the committee's true objectives. Instead, Bragg contends that the subpoena is actually intended to undermine and obstruct New York's criminal case against Mr. Trump and to retaliate against the district attorney. The court cannot passively accept this contention. The court is required to presume that a congressional committee's stated legislative object is the real object. Moreover, even if Bragg's hypothesis about the committee's real motivations were correct, they are irrelevant. It is not a court's function to invalidate a congressional investigation that serves a legislative purpose. Again, this really does read like it was authored by Jim Jordan's PR person together with Donald Trump's criminal attorney. Judge Vyskocil's ruling continues to gratuitously beat up on Bragg and Pomerantz. Turning to page 17, Bragg and Pomerantz are not entitled to unilaterally narrow the universe of acceptable inquiry to the information and mental impressions that Pomerantz decided to sell in the pages of his book. I mean, that kind of nonsense should be beneath any federal judge, but not Trump-appointed Judge Vyskocil. Her ruling continues. The court is further unmoved by Bragg's purported concern at the prospect of injecting partisan passions into a forum where they do not belong. By bringing this action, Bragg is engaging in precisely the type of political theater he claims to fear. Again, as if it was authored by Jim Jordan's PR person and Donald Trump's criminal attorney. Judge Vyskocil continues. Bragg's throw everything at the wall approach to privilege is unpersuasive. Although Bragg vaguely asserts that the committee's inquiry could still include questions about grand jury matters, this court will not quash a subpoena based solely on Bragg's seemingly endless string of what-ifs. Again, I hear something that sounds like it was drafted by Jim Jordan's PR person and Donald Trump's criminal defense attorney. And here's the kicker, friends. Here is the conclusion to Judge Vyskocil's ruling. This court will retain jurisdiction over this dispute and any ancillary claims arising out of the inquiry by the committee relating to the use of federal funds in a manner that may influence the 2024 presidential election. In other words, Bragg may not file successive proceedings under a different index number if and when the committee in fact issues another subpoena that he finds objectionable, or if there are issues with respect to the Pomerantz deposition. Oh, really, Judge, you'll be retaining jurisdiction over this matter? No, you won't, because the Second Circuit Court of Appeals has already stayed, that is, paused, put a temporary stop to your ruling and to the Jim Jordan subpoena to Mark Pomerantz, trying to compel Pomerantz to testify at the Jim Jordan Let's Protect Donald Trump circus. The Second Circuit Court of Appeals has already put a temporary hold on all of that while it decides if it wants to hear an appeal of your ruling. Because justice matters, Judge. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.